Mr. Pennington-Benton.
Thank you, my lords, my lady. Just before the adjournment, I had finished making some submissions on the intention point. There was just one point I wanted to emphasise back on that, better to make it now rather than later, and that is that the judge, included within the judge's summing up, is the entirely orthodox proposition that one can take a defendant to have intended the natural and probable consequences of their act, which reminds me of law school. I think I remember the first year law proposition. But the point is that, of course, in this case, when we are considering the allegation that the judge didn't put an independent case of intention to the jury, once the jury rejects self-defence and rejects provocation, there is a very, very, very narrow space, if any space at all, for a submission that somebody can plunge a knife 3.5 inches into somebody's neck and not intend the natural and probable consequences of that. Especially when one looks through that, at that question through the prism of section 12(3) of the Penal Code.
Mr. Pennington-Benton, I should perhaps mention that the board earlier this term has heard another appeal in a case called Miller.
Yes.
Which is also, I think, it is from Barbados. It certainly is from Barbados, and it involves Bahamas. I'm sorry.
That's okay.
I'm so sorry. From Bahamas, and it does involve section 12, subsection 3.
Yes. I don't know the case, I'm afraid. Tim.
Well, there's no judgment in it.
Oh, I see. Okay, well, that explains it.
It was heard a few weeks ago.
I see. And presumably which way the test of whether the law presumes that he intended and whether there's a burden on the defendant, presumably. Yes. Well, the other point, I just wanted to make one quick point on language. You would have seen the transcript of the appellant's evidence, and in my respectful submission it shows that his English is not bad. And then secondly, the judge in his summing up at page 242, line 20, says the appellant spoke, it is a matter for you, you may think it is a matter for you that he spoke English well without assistance. And then finally, the Court of Appeal.
What was the page in the
242 for the judge's summing up, line 20.
Okay.
And then finally, the Court of Appeal, when considering the merits of ground 1. Round 1 concerns the admissibility of Officer Cash's evidence. Officer Cash went to find the appellant on the day of the killing and approached him at a place called Mud in Abaco in the Bahamas. And Officer Cash's evidence was that at that stage, after being cautioned in English, the appellant said to Cash, Shima came to my front door, called me a sissy, and I stabbed him. That's at 71 of the electronic bundle, that's the evidence. And there was an argument in the Court of Appeal in this case as to whether that evidence should have been admitted because of the language issue. The point made by appellant's counsel, look, did he understand the caution that was being given in English? And the Court of Appeal said during the hearing of the extension of time application in this case, so during the oral exchanges, Justice of Appeal Evans said if he understands English, that is sufficient, and the indications are that he understands English. That's at 10.48, line 19. And then generally there's further discussion on the point at pages 10.53 to 10.55. So it appears that both the judge and the Court of Appeal seem to think that his standard of English was sufficient, although of course the Court of Appeal I don't think will have heard him, but the judge certainly did. Finally, just before I get on to the submissions on the law and what I say should be the correct test and so on, I wanted to deal with section 2992. That's at 1325 of the bundle. That's where we'll find the provision of the penal code. And I don't think there's any dispute that provocation was put to the jury, but the criticism appears to be whether subsection 2 was put, whether the appellant was justified in causing.
If self-defence fails because excessive force is used, is that right?
Yes, but I wasn't sure for myself, for my part, and I'm still not sure, and I just raised the point now that how that ties in with the complaint about intention. Sure how it relates to it. There doesn't seem to be any nexus between that and the complaint about intention. It's simply a question of whether, if the jury rejected, my first submission is the jury plainly rejected the factual case of self-defence.
Yeah, the complaint, as I understand, is that this possibility, which would reduce it to manslaughter, wasn't put to the jury.
No. But you need to get to, first of all, the factual condition, which is that he's acting from such terror of immediate death or grievous harm as deprived him from the time being of self-control. And the point is, if you reject provocation, I'm not sure how you get to that.
But this turns on losing the power of self-control, as does subsection 1.
Yeah, so if it's rejected, that's it.
Right, subsection 2 is not talking about the defence which is now being posited, which is that he did stab him, but just in order to get loose from his grip or whatever.
Yes.
Which is different from self-control, from self-defence or losing control.
But you have to have acted from terror of immediate death. I mean, surely the jury, rejecting provocation, rejecting self-defence, much have rejected that factual precondition, because otherwise you would have met.
Yes, but if he only caused harm, a proportionate harm, then he'd be acquitted of everything.
Yes. Well,
if he was acting in reasonable self-defence.
Yes, if he was acting in reasonable self-defence, there's no question of being.
But the jury must have rejected that, mustn't they?
Yeah.
Yes.
So therefore, this is irrelevant. Unless I've misunderstood how it relates somehow to the intention point. So, my lords, my lady, that then brings me on to submissions on the authorities and the legal tests that I say, or the respondent respectfully submit, should apply. I'm going to break my submissions down into 5 parts. The first of all, what I respectfully submit is the correct interpretation of the Court of Appeal's decision in Williams. Secondly of all, what the respondent respectfully submits is the correct test for an extension of leave where there is long and unexplained delay. Thirdly, whether the Court of Appeal applied the correct test. Fourthly, whether the Court of Appeal considered all grounds of appeal, and whether it was sufficient for the Court of Appeal to focus on the grounds it did, or whether it was required to provide reasons on every single point. And then fifthly and finally, I deal with some miscellaneous points raised by the appellant in the case, points that I say weren't raised below. So the Court of Appeal decision in Williams, tab 6, page 1356, 1356.
Again, please.
1356. That's where it starts. We are looking, of course, at paragraph 15. inexorable, notwithstanding the length of delay and the absence of good or sufficient reasons for the delay. So we're definitely talking about the same category of case, no doubt about that. Because the delay in this appeal was over 6 years, and there's no challenge to the finding of the Court of Appeal that that was a delay without explanation. If the prospects of success of the intended appeal are good, then this court would nevertheless grant an extension of time and hear the appeal, provided there's no prejudice to the other side. Good, in my submission, means what it says, good. And the reason why the court is looking for good merits is because if the period of delay is long and unexplained, then those elements making up the interests of justice, namely certainty, finality, victims, and so on, will almost always outweigh a very long extension of time unless the prospects are really good or good. And that's just logical. What is not logical, and therefore is unlikely to be what the Court of Appeal intended, is to lay down a general rule that good prospects are enough. So my primary submission is that's not what the Court of Appeal here meant. It was simply saying on the particular facts of this case, having looked at everything. However, if the language in paragraph 15 doesn't permit me to make that point, and I can see on one view it may not, then the decision is just wrong.
It may reflect general rather than variable practice.
Yes. And of course...
But I mean, paragraph 15 is at least contemplating that there may, even if there are good prospects, need to be some sort of way of getting prejudice to the other side, because here it's put in terms of there is no prejudice to the other side. In other words, nothing goes in the balance against it, but that seems to contemplate, well, there could be something that goes against it, and then...
Yes, but in my respectful submission, it's not limited to prejudice, which I take to mean a reference to, for example, the evidence is no longer available. For example, in this case, mud, the area where a number of the witnesses lived in Abarco, a Haitian area of Abarco, was largely swept away in Hurricane Dorian. You can't get hold of the witnesses, for example. That was the prosecution's position in this case. But it's not limited to that sort of prejudice. It includes also concerns about finality and the rights of victims to have closure on these things and so on.
But if good means good, why does the interests of finality outweigh the prospect of someone spending another 30 years in jail when they shouldn't be there at all?
Well, Your Lordship's question, of course, is posited on a particular set of facts, and one of the...
Well, I'm positing it on, not on a particular set of facts, but in any case where, and I'm talking about a serious charge here,
Yes.
the prospects of success are good.
Well, again, with respect, my Lord, I'm presented with another proposition, which is a very serious charge. You have to look at everything. I accept, my Lord, if Your Lordship's saying to me, listen, there's a murder case.
Well, this was it. I mean, they're talking about murder case here.
Well,
I mean,
they're not saying only in murder cases, though, are they? Or are they saying only in serious cases? It just, the fact of the matter is, and I'm going to take Your Lordship to the case in a moment.
well, take a murder case.
Yes.
Are you saying that the proposition is wrong in 15?
I am saying there must be left discretion to the Court of Appeal to take into account all the circumstances of the case, including, for example, someone who deliberately hasn't appealed for a number of years for whatever strategic reason, hoping for some change in the law and so on. There's all sorts of facts that you just don't know. It doesn't make... it's a bad idea, I say, to ever try and create a rule that just because someone has a good appeal on the merits, they have to be given an extension of time, no matter how long the delay, no matter the other circumstances of the case. That, in my submission, is a bad
you must leave discretion in the court. You mustn't lay down a sort of rigid rule.
Yes. But I would accept, of course, that other things being equal, if someone has a corking appeal chances are in a serious case for a long sentence, they're going to get an extension of time, because otherwise you're basically letting somebody stay in prison when you know they perhaps ought not to be there.
Sounds like a substantial injustice, a risk of substantial injustice.
Exactly, my Lord. And my Lord, I do plea in aid, if I can put it like that. And I'm on my submission 2, which is, well, what is the correct test? And I do respectfully submit to the court that substantial injustice is the correct test in a case where there has been long and unexplained delay. And I'll come to my Lord Hamblin's point in a moment that, well, that test is not itself rigid and inflexible. It's multifactorial and it involves weighing various different considerations in the balance. But the point is that where you have a long period of unexplained delay, the starting position in the scales of interests of justice are against you, because the rights for victims and certainty and so on are strong, because they've become somewhat concretised over a long period of time. Anyway, so the case that probably best illustrates this, or one that best illustrates it that's in the bundle anyway, is at tab 26, which is the case of Yaxley Lennon. It is not a murder case, or necessarily hugely serious offence. 2 charges. Page 1662, the case starts. This is an appeal by Mr. Yaxley Lennon. He was found guilty on 2 charges of conspiracy to commit fraud by misrepresentation, mortgage fraud, basically, and then as part of what has been treated as a sentence, a confiscation order was made. He appealed 2 years out of time. He was ordered at first instance to pay £116,985 by way of a confiscation order. He then appealed 2 years out of time on the basis that the quantum was wrong.
Although he'd agreed it. They agreed some of the figures.
Exactly. But counsel below had agreed the figures, but they'd agreed the figures on an erroneous assessment of the law. And what the Court of Appeal says at paragraphs 18 to 20, this is at 1665 of the bundle, starting at paragraph 18, Mr. Evans, counsel for the appellant, submits it's not appropriate given the circumstances to grant the length of the extension. Paragraph 19, counsel for the other side's point remained that there would be a substantial injustice, so they're applying the substantial injustice test, if the defendant were left with a benefit figure which was an incorrect figure and would be out of line to the tune of some £30,000. However, paragraph 20, in our view, it would be contrary to the good administration of justice to grant so lengthy an extension of time as now sought, an extension for which no reason has been given. And last sentence, this court will not speedily or readily depart from agreements as to the benefit and realisable assets made in confiscation proceedings by properly instructed and experienced counsel on an advised basis. And then at paragraph 23, no doubt a differential of £30,000 can be described as a significant sum. However, substantial injustice, last penultimate sentence, is not to be calculated simply by reference to the amount of money at stake from the point of view of the defendant. Substantial injustice has to be calculated by reference to all the circumstances of the particular case. So it's just a decision on the facts, and I don't put it to the court to be anything more significant than that, but the point is it demonstrates why it makes sense not to simply say, well, if you've got good merits, then you get your extension of time. And of course, I accept my Lord Richard's point, well, you could perhaps limit the scope of that rule to serious offences, but then you start having arguments
about... Well, we're talking here about a murder case, and Williams is a murder case, so shouldn't we really rather than trying to think of a general formula applicable to all cases, be focusing a little on what we are concerned with, which is murder. And a minimum sentence in the Bahamas of 30 years, that sets a rather different context, doesn't it, to a confiscation order which was agreed by council, which transpires to have been £30,000 too much.
Well, I
the
agree.
context is so different that we may be in danger of broadening the focus so wide that it becomes an almost pointless exercise.
Well, my lord, the point I'm trying to make is that the case against me, at least in the written cases, is that Williams stands for a bright line rule, and all I'm saying is, well, it shouldn't be interpreted in that way, and there shouldn't be a bright line rule. Now, your lordship...
Why, in what sort of case would it not apply in murder? Well, I mean, are you able to cite to us any authority in which the court has concluded that there are good prospects of success, but has nonetheless refused an extension of time in a murder case, or attempted murder, or other very serious crime?
No. I think I think I would accept that in most, possibly nearly all, of such cases, the only rational exercise of the discretion that I'm talking about would be in favour of the defendant. But there is no need, first of all, never say never, but secondly, there's no need to try and impose, nonetheless, a rigid test in circumstances where the application of a flexible test will reach the right result in the right cases. Why impose a bright line rule in cases where judges must know? Any judge that's looking at a case like that will make that decision. I suppose the closest I come is the comments made by the board in the Joghi Ruddock case, the joint enterprise case, where the law, the concept of parasitic accessorial liability was reversed, and the board basically said, I'm afraid I'll have to come find the reference, but basically said, look, that doesn't mean everybody that's been convicted of joint enterprise gets off. The test for an extension of time is substantial injustice. And the fact that there's been a change in the law alone isn't enough. So even in those sorts of cases, very serious cases, murder cases, parasitic accessorial liability cases, these substantial...
There are a lot of cases where it was refused.
And many cases where it's been refused. Some people say for different reasons, but yeah, extension of manslaughter, whatever. But yes, there have been many cases. And I would have taken your lordships to, but do not need to, the case of Thorsby that your lordships, my lady, looked at earlier today, where the court makes the valid and proper point that significant injustice is not a test that is looked at purely through the lens of the effects on the appellant, or would-be appellant, but is looked at through the consideration of all of the factors that make up the interests of justice. And therefore it's a perfectly acceptable test to apply, as it does apply at the moment in change of the law cases, and as it does apply at the moment in, I submit, in long and unexplained delay cases.
So you're saying the general test is interest of justice, but where you have a long and unexplained delay, in effect that means you've got to show substantial injustice or significant injustice.
Yes, because application of the interest of justice test to a case of long delay will ordinarily point away from a grant of leave, and therefore you need some, and that's one point. And then the second point is that in showing substantial injustice, the reality is, and this is not the Court of Appeal in this case being inflexible, it's the Court of Appeal being practical and real about it. The only thing an appellant can do in those circumstances, when he's got absolutely no reason for not appealing for 6 years, is say, but I've got this great ground of appeal. And therefore, the net effect is really what the Court of Appeal in Williams and in my case, in this case, we're getting at, which is, look, if you come to the court with a massive delay and no explanation, you better hit us with a good ground. And in my respectful submission, that's not being inflexible, it's just being realistic.
Yeah, so that's really your answer to the submission made this morning, that it's necessary only to show an arguable ground.
Yes, in my submission, there is no threshold merits test. I haven't seen it in any of the authorities, and it's a matter of looking. I think my Lord Sales may have referred to a variable standard. In some cases, the merits will jump off the page, and therefore you can take that into account even at the extension of leave time stage. Other times the merits will be more difficult, but it's up to the appeal court to take a view on the merits and stick it on a scale somewhere from not very good to arguable to brilliant, and then to juxtapose that consideration against all the other considerations. It's not about
exactly what the Privy Council said in Hamilton.
Happily, it is also exactly what the Privy Council said in Hamilton. So the third part of my submissions is sorry, I should just very briefly refer to, I won't take your lordships to it, but I'll give your lordships the reference. It's the case of the Crown and Patterson. It's an English case from the Court of Appeal, tab 20, which is at page 1573. That was an appeal by the consultant surgeon who had performed a series of unnecessary operations, mastectomies and so on the alleged but false basis that there were cancerous tumours and so on. There were, paragraph 22 of the judgment, wholly inadequate reasons given for the delay, and the Court of Appeal pointed out correctly in my respectful submission at paragraph 27 that
A trump card.
It's not a trump card.
What they said was an arguable case is not a trump card.
Yes. So I suppose you could say, well, it still leaves open argumentation.
They say arguable case.
Yes, so it leaves open at least, would they have taken a different view if the merits were good?
Exactly.
Yes, fair enough. Thank you, my lord. And then, so I'm now on section 4, which is, sorry, no, I'm not. I'm on section 3, which is whether the Court of Appeal applied the correct approach. And I think it's fair to sum up the case against me as it was put this morning. Well, the Court of Appeal was too rigid in its approach. So, my lords, if we could just turn up the Court of Appeal's judgment at page 814. 6 years delay. Page 815 sets out the grounds of appeal. Over the road at
page
815, that's where the grounds of appeal are set out. I'll come back to those in a moment. Paragraph 6 is the finding that there's no real explanation for the delay. What the Court of Appeal then says at 818, paragraphs 8 and 9 and 10, I don't need to read that out, but I respectfully submit that insofar as that's suggesting that Williams was wrong, insofar as it suggested the existence of a bright line rule, that decision was not correct.
Sorry, which decision?
In Williams,
yes.
Insofar as Williams can be taken to stand for the proposition that wherever there are good merits, you have to grant a leave, you have to grant an extension of time. That decision can't be right. And then,
I didn't altogether understand the last sentence, paragraph 10, that it would be inconsistent with the purpose of the time limit imposed by Parliament. I mean, William still leaves plenty of opportunity for refusing to extend time. I don't know that one can really discern from the words of the statute a parliamentary intention that leave would normally or always be given if the prospects were good.
well, I think the proposition was, my lord, simply that there is a broad
I see.
discretion,
Broad discretion, right.
and therefore it's not right for the courts to start creating rules out of that broad discretion.
Okay.
And then, please, to page 821, I think we've already been to these passages. The grounds of appeal were considered, as of course they should be, because it is one of the factors that, a very important factor, that the Court of Appeal needs to take into account. We heard submissions, and I'll take your lordships to some of the transcript in a moment, not all of it, because it wouldn't be proportionate, but I'll take lordships, ladies, to some, if I may. Paragraph 21, we heard submissions on the prospects of success. The Court of Appeal rejects ground 1. That's the challenge to the admission of Officer Cash's evidence about the oral confession. The transcript reveals that the applicant understood the English language and never suggested that he did not understand the caution. And then they also reject the complaints about competence of counsel, and there was affidavit evidence about that. Then they move on to ground 9. And this is the point we've already been over, therefore I don't need to go over it again, which is, well, look, what exactly was the appellant saying? And generally, more generally, did the judge give a proper directional intention? In my respect submission, he did. We then come to paragraphs 26 and 27, which are on page 824. And it's really, I think, paragraph 26, where it said, well, this is expressed in too rigid terms. In my respect submission, one has to read the sentence beginning, unless it can be demonstrated that significant injustice would occur unless the extension is granted, then the court should dismiss the application. One has to read that sentence with the sentences that precede it, and reasonably infer from that that the Court of Appeal was accepting that the categories of, for example, a case of high constitutional importance or other exceptional circumstances were not closed categories, they're just examples. And there is support in the case law for the idea that if someone's raising some point of law, that may be a good reason to grant leave. Therefore, the Court of Appeal is perfectly entitled to single those examples out. But the Court of Appeal plainly, in my respectful submission, if one reads paragraph 26 in light of paragraphs 19 to 21, is plainly accepting that if the grounds of appeal show sufficient merit, that alone will be enough. And my lords, I say that
You
is...
say they accepted Williams, the formulation in Williams, you say?
The bit of Williams that they don't accept is the bright line rule. But what they do say is generally, if you can show, if an appellant can show good merits, that may well be enough to get the extension of time.
They don't actually say that, I don't think.
Well, they don't actually say that, but I say that's a reasonable inference from the citation.
Yes.
Can I add one more point to this, my lord? Because
they sort of say that it's... yes, I'm not quite sure why they just didn't stick with the second sentence in 26, unless it can be demonstrated that significant injustice would occur. Unless the extension is granted, then the court should dismiss this application.
Well, they could have done, but all I'm saying is that the categories of case that are identified in the words preceding
Yes.
are perfectly, could be
Well,
perfectly...
they are perfectly good, but they don't cover, do they, the case where there are good prospects of appeal,
No.
of a successful appeal.
But, my lords, it is made clear in my submission in the transcript that the Court of Appeal were proceeding on the basis. Can I just take your lordships to that transcript? Because it's quite a pithy judgment, one does have to read it in light of the transcript. Because, my lord, in this case, my lady, in this case, there were 6 hearings in the Court of Appeal. 2 hearings where the appellant wasn't represented right at the beginning, but then 4 substantive hearings, by which I mean counsel submissions. And I've counted up the hours because I'm sad, and they come to 5 hours of Court of Appeal time, arguing these points extensively. So although you have quite a pithy judgment, you do actually have a significant amount of time devoted to this case. And as your lordships will see, certain things are said during those oral exchanges that make it clear that actually the Court of Appeal was well aware of this, the good merits point. So the first reference is at 994. Just this is at 994, line 5 to 6. This is just prefacing this by a discussion about delay. And then at the bottom of 994, lines 22 to 25, about the authorities normally advising persons of the right to appeal and so on. And then 995 at the top, more of the same. And then at 996, per Justice of Appeal Evans at line 6. Sorry, this is an exchange between Ms. Cadet, who's the appellant's counsel below, and one of the Justices of Appeal. Sorry, the most that you could be saying is that, listen, there is no good reason for this delay, but that his grounds are so overwhelming, the President interjects, compelling, Justice of Appeal Evans continues, that justice requires us to look at it. That is the only thing I could hear you to be saying, and you will have to come very good with that ground. Speaking for myself, I do not see any justification for this, could be acceptable for this kind of delay. That's putting it quite high, I accept. My lords at lines, but I think to some extent they're just giving counsel a slightly hard time. But anyway, lines 16 to 17, Ms. Cadet, who does a pretty good job of pushing back on the point, says, we submit there are good prospects of success on the grounds. We will hear you on the prospects, says the President, bearing in mind that it is your only ground because the delay is inordinate and inexcusable, and you're going to have to persuade us that the interest of justice is so compelling that notwithstanding the inordinate and excusable delay, we should hear this matter. Well, in my respectful submission, that is right. That is the correct approach.
Well,
it's a bit
it's not
stern.
what they put in their judgment, and they don't.
My lords, what they say in their judgment is you must show substantial injustice. We've considered the merits, and the merits don't have, and there are no merits.
I must say a test of overwhelming would go much further than any authority does.
Well, it's compelling.
Well,
We submit that there are good prospects of success. Well, my lords, perhaps I can put it a different way. That is, if the court is using slightly extended language here, then it might be better to use, good prospects or compelling prospects. That may be more appropriate.
One can really look at extracts from the transcript of the hearing to interpret what was said or change what was said in the judgment. The judgment sets out the reasons for the decision. I'm not quite sure what we get from this.
Well, because, my lady, it's not changing what's in the judgment. All they say in the judgment is substantial injustice. And here, during the hearing, they're making it clear what the Court of Appeal understand by substantial injustice. What they mean is that justice requires us to look at this because the grounds, and the Court of Appeal must have had in mind the point made in Williams, although too rigidly, and the point made in the other authorities that we have been looking at, that if the merits are good, you might well get home even after a 6-year delay. It's not a question of changing the judgment. It's a case of understanding what the Court of Appeal meant in a pithy, short judgment. And in my respect to the Commission, there's no reason why one shouldn't look at things that are said during an extensive hearing on the matter, especially when we look at, in a moment, the lack of reasons. And then there's another reference finally at 1003. Line 11 onwards. The President, Ms. Cadet, I do not mean to be disrespectful, but you have a 5-year delay. The only way you can persuade us is if you could tell us that there is a really compelling prospects of success on your appeal. In other words, what the President of the Court of Appeal is saying is that if you show that there are really compelling prospects, I might well extend time.
Well, that is to set a much higher test than any authority would warrant. And the fact is they don't put that into their judgment, and they may have perhaps had thoughts about that.
Oh, yes.
But are you submitting to us that the correct test is either overwhelming or really compelling prospects of success?
Respectfully, my Lord, I don't... I don't say there is a threshold on the merits. What I say is that the court has to look at the merits and decide whether they're, are arguable, good, bad, excellent.
So are you relying on this to counter an argument that might be made against you that because they listed a group of categories of constitutional challenge or change of law, that they then closed their minds to this case because it was not within one of those classes, but you're saying, albeit they may have misstated the test here, they were applying a merits-based test.
Exactly. In other words, it's wrong to submit that the Court of Appeal didn't consider the merits. They did consider the merits. They may have overstated the test, but in actual fact, because the Court of Appeal said none of these grounds have got any merit apart from the intention point, it doesn't matter.
Well, if they'd said that, then we wouldn't have this appeal, I dare say.
They did say that. They did say that. Paragraph 19 of the judgment. That's precisely what they said. Sorry, not paragraph 19. Paragraph 22.
But they gave permission to appeal, didn't they?
Yes,
on the basis that it appeared that there might be disagreement or difference as to what the applicable test was.
But actually, the point on which special, whatever you call it, if it's the Court of Appeal that grants it, but was actually on this point about the rigidity point, if I can put it like that. In other words, is there a bright line rule? Good prospects, equal extension of time.
Okay.
But this is a slightly different point. But what their lordships in the Court of Appeal say, or what Sir Michael Barnett says at paragraph 19, to this end the Court had regard to the issues raised by the appeal. The grounds of appeal involve no important, etc., etc. We heard submissions on the prospects of success in this case at paragraph 21. Paragraph 22, the only issue raised by this appeal that had any prospect of success was whether the judge was clear in his direction about intention. So the Court of Appeal has said that these grounds don't have any merit apart from this one. And therefore, if the Court of Appeal overstated the test somewhat, then fine. But equally, this is a very long period of delay. The worse the delay, the more compelling the grounds have to be. And of course, counsel is being told in cross-examination, look, give us your best point. I mean, there has to be a certain amount of leeway for a degree of perhaps hyperbole, but basically saying, because the counsel is going on about all sorts of other points, the Court of Appeal is saying, look, give us your best point, because that's your only hope here. But implicit within that, yes, my Lady Rose, that means the Court of Appeal was saying, look, if there is a ground of appeal here with merit, we'll look at you.
Could I just ask you on paragraph 27 of the judgment of the appeal? whether you support the last sentence of paragraph 7.
If yes, if you read that as being subject to the caveat in the third sentence from the bottom in paragraph 26.
Sorry, subject to the caveat of?
Unless it can be demonstrated that significant justice.
I mean, given the whole context is criticism of the rigid rule in Williams, a bit odd if they were then laying down their own rigid rules.
Yes. I think one has to... The starting position is if there's a long period of delay, the starting position is there better be good reasons for it. It's only when there are no good reasons for it that one then shifts to, well, look, does it raise some interesting constitutional point? Is it some interesting, important point of law? Or is there substantial injustice cause because actually you've got good merits and you're serving a long sentence? So one has to read the last sentence of 27 in light of everything else that's been said, and in light of the fact that the Court of Appeal sat through 4 separate hearings looking at the merits. I mean, if the Court of Appeal didn't think the merits were important, they wouldn't have spent all that time doing it. So in my respectful submission, the Court of Appeal plainly did have a good, long, hard look at the merits. I'll come to the question of reasons in a second. It did obviously look closely at the merits. It received 4 sets of written submissions on various grounds, including supplementary submissions, adding grounds. It received 5 affidavits from the appellant, and it held 6 hearings, 4 substantive, all dealing, the last 4 all dealing with the question of merits.
With the
Question of merits. The Court of Appeal provided reasons on grounds 1, 4 and 9, that's Cash's evidence, counsel incompetence and intention. Ground 2 was abandoned. Ground 5 raised good character, but in actual fact it wasn't pursued as far as I can tell in the Court of Appeal, and in any event there is a clear direction on good character.
The complaint seems to be that only one limb was provided, but it wasn't. Both limbs were.
Both limbs were provided, yes. And the reference for that is pages 262 to 263. So that leaves grounds 3, 6, 7 and 8.
Sorry, the pages 22.
Sorry, my lord, 262 to 263. That's the good character direction.
Yeah, thank you.
So the lack of well, there was a lack of reasons in respect of good character, but then again, as I say, there just wasn't a good point. It just wasn't runnable, basically. So that's how I get around that. So I have left, as it were, grounds 3, 6, 7, and 8, where there are no reasons. And my first submission, unsurprisingly, is, well, this is an application for an extension of time, not an appeal. There is an appeal as of right in criminal matters in the Bahamas, and therefore if you appeal in time, you get an appeal. So I'm not sure the relevance of this point about whether there's an arguable merit in the grounds. I mean, you just get a right of appeal, and it's heard. And if the grounds of appeal that you raise are rejected, you get reasons for that. But here, where you apply for an extension of time, you're actually applying for a reinstatement or an instatement of an appeal that you've lost. And the judicial exercise is trained towards balancing the various different elements that go up to make the interests of justice. They include the merits, but they can't, with my respectful submission, include in every case giving reasons for rejecting each ground of appeal, because if they did, you would just have a right of appeal. There would be no difference between an application for an extension of time and a full appeal, because all that happens in a full appeal is they consider the grounds and then tell you why you've lost or won or whatever. He does not have a statutory right to appeal, so when he applies for an application, when he applies for an extension of time, the appellant is entitled to a measure of procedural justice, which includes being told, if any of the grounds have some merit, why that merit isn't enough to outweigh the other things, certainty and so on. But what he doesn't have a right to, in my respectful submission, is some slavish set of reasons why the appeal court doesn't think any of the other grounds are any good. It is not sufficient in my submission simply to say, well, look, no reasons equal bad decision. You do have reasons for refusing an extension of time, you just don't have reasons for reasons. Toyed whether, in my mind, whether to raise this next point, but of course not all decisions about extensions of time and applications for permission to appeal get reasons other than conclusionary reasons, including, for example, special leave applications to the board, where one just gets told, well, you either meet the special leave test or you don't. Nobody tells you why an extension of leave application was or wasn't granted. And nobody gives you reasons.
Is that you're talking about what the board says?
I'm just giving by way of an example.
Not what the Court of Appeal does.
The fact that when...
No, I just,
yes.
sorry, just, it's a question only.
Sorry.
You're talking about what the board, the practice of the board here,
Yes.
in refusing special leave.
Exactly.
Yes,
I'm just giving that as an example
but
of decisions on extensions of time where there are no reasons provided for the underlying rejection, what must be the underlying rejection of the merits. But in any event, the fact is here, this is my second submission, it would have been tolerably clear to the appellant's counsel why the Court of Appeal majored on ground 9 and didn't think much of the other points. I'm going to just demonstrate that by reference to ground 3. It applies to the other grounds too, although with less force, but I'll choose ground 3 for obvious reasons. But this concerns the evidence of Jean Marshall. It might be worth just very briefly looking at that evidence. So ground 3 concerns whether the judge erred not giving a direction about Jean Marshall's evidence and his potential motive to lie. So Jean Marshall is the person who says he witnessed an exchange between the appellant and the deceased, and then he saw the appellant, turned around, heard something, looked back and saw the appellant taking the knife out of the deceased's neck. Can I just ask your lordships please to turn to page 32 of the transcript, of the electronic bundle, sorry. Before I go here, I should just preface this with a brief explanation of the basis of the alleged motive to lie. So what the appellant's counsel was saying in the Court of Appeal is there was evidence before the judge that Jean Marshall had been arrested and it was possible that Jean Marshall had in fact been arrested for this offence. And that created an obvious motive to lie, because of course if he could pot the appellant for it, then he would be released. The basis for that suggestion begins on page 32 of the transcript. This is Jean Marshall's evidence, line 17 onwards. Did Jean-Pierre remain there after you saw him pull the knife out? No, because I was to the police station on the 26th. Mr. Henfield, who's one of the officers, take 9 of us behind something where I could see them, but they couldn't see me. Further down on the same page, 28, yes. That is the same time the inspector, Mr. Henfield, get 9 of us from the cell. He put me inside a room. I could see them outside. They couldn't see me from inside. Over to the next page. Each of them had a number on page 33 of the transcript at the top. And you said Jean-Pierre had number 4. Did you do anything when you saw Jean-Pierre? Mr. Henfield asked me which number it is, and I tell him, Mr. Henfield, that was Jean-Pierre who had number 4. So this is obviously an ID parade, but the proposition was, well, the mention of the word cell on line 29 on page 32 implied somehow that maybe this witness had been arrested, as opposed to just put in a cell waiting to go into the ID parade.
That wasn't pursued in cross-examination.
No.
That's it. That's the only evidence on this point.
Yeah.
So is this evidence?
Did Mr. Marshall know Mr. Pierre before this?
Yes.
Yes.
They'd known each other for 17 years, and there was some suggestion that they didn't get on very well. And there was another piece of the evidence, I think, suggested that
It's a bit odd doing an identity parade of people who know each other.
yes. Well, I don't think actually it was ever it was pointless, because there's no doubt about ID. And it's actually rather curious ID parade, because everybody seems to be seeing each other. But the point for present purposes is your counsel didn't cross-examine Mr. Marshall on this point. No further evidence was elicited on it. And the Court of Appeal, during the oral hearing, unsurprisingly, made their thoughts pretty plain about this.
He's also talking about 9 of them coming from the cell.
Well, I know, I'm not quite sure what sort of weird ID parade this was, but whatever. But it was obviously, if it needed to be relied upon, which it didn't, there may have been some problems with it. But the point for present purposes is
So you say there's no basis for the suggestion Mr. Marshall would have had any motive to lie.
But the real point I'm making here is not only that that particular ground wasn't very good, although I could do that for all of the grounds. What I'm saying is the Court of Appeal looked at it. So the submission is, because the submission against me, of course, is this is not an appeal against conviction. This is an appeal against extension of time, and the argument is the Court of Appeal didn't look at this. And my answer is, well, of course they did. And one can see that because there's extensive argument on all of these points. And if one turns, please, to page 1011. 1011, 1011, as it were. Actually, apologies, if your lordships wouldn't, my lady wouldn't mind turning to 1010 to start with, at line 16. This is during the course of oral submissions on this point. The President says you are speculating, you're asking us to infer certain things, etc.
Sorry, which line? Oh, yes, I see.
Line 16, yes.
Sorry.
And then over the page on 1011, at line 8, the President says, well, I think this is a suggestion, because he was an accomplice. Maybe that's the suggestion, that actually this witness, Jean Marshall, was an accomplice. And then Ms. Cadet says, well, there should have been a direction that his evidence may be tainted. And then the President says at line 17, you see, what annoys me is that you keep saying that he was in custody in relation to this matter. There's absolutely no factual predicate for you to make that argument. And then that continues later on. I'll just give your lordships the reference without taking your lordships and my lady to it. It's page 1059 to 1060, where again that point is made clear. So it's a bit hollow, if I can borrow the Court of Appeal's language, for an appellant to complain that there are no reasons given for a decision when the Court of Appeal is telling you during the course of the hearing this is a rubbish point. And my lords, I do say the same with respect to the other grounds. Unsurprisingly, I've selected my strongest point, but
You could take ground 6, for example. There's no basis for giving the Lucas direction.
no, it tied in with the intention point anyway. Ground 8 was on sentence. Well, the minimum sentence for murder is 30 years. The range goes up to 60. He got 35. Well, the board's never going to, well, the Court of Appeal is never going to interfere with that sort of sentence. Ground 7 raised a number of points, for example, provocation. It was accepted that the judge put to the jury the appellant's evidence that the deceased had thrown a rock at him, had tried to strangle him, and had threatened to kill him, and had called him a sissy. But the criticism was that the judge should also have put to the jury that the day before the killing, the deceased dog had bit him.
Sorry, is this? I'm just actually looking at the appellant's case, and they do discuss these grounds. I'm just trying to see what is being said about them. Do they take up this one?
Well, I believe
Yes.
it is proceeding.
Sorry,
They do in paragraph 43, I think.
Yeah.
43, sorry.
Well, they take up these grounds, but take up different points that weren't
Different
part
grounds,
of
the
those.
different grounds. These.
Well, the ground 7 is what I'm talking about now, the provocation point. But this point is actually a new one.
So whose dog bit whom?
So the allegations, the evidence suggested that the deceased dog bit the appellant the day before the killing, but that on the day of the killing, in addition to calling the appellant a sissy, the victim, the deceased, also said to him when the appellant complained about being bitten by the dog, the deceased said to him, well, the dog's Haitian, the dog's Bahamian, you're Haitian, so the dog's got a right to bite you. To which the Court of Appeal said, well, it's all very interesting, but basically, once you put the point about a rock being thrown at him and strangled and called a sissy and all the rest of it, what more to the party did this sort of allegation bring? And nobody heard it. So there was nobody else accepted that in fact happened. So, my lords, the rest of the references are in my case. I don't propose to take your lordships through why each of the grounds isn't very good, and the more pertinent point that the Court of Appeal did look at the grounds, and that it would have been tolerably clear to appellant's counsel why those grounds didn't get anywhere, and therefore, to the extent that there was a problem in not giving reasons on each and every ground, looking at the matter in the round, the appellant can't say he's sitting in prison thinking to himself, goodness me, why did all those grounds get rejected? Perfectly obvious.
You say, well, we're not entitled to reasons because this wasn't actually an appeal, it was only an extension of time, and that we should effectively read paragraph 22 at page 822 as saying, we've looked at all the grounds, the only one that has any prospect of success is this one, and this is the reason why we nonetheless don't think time should be extended.
And in the context of a case where there is unexplained delay, and therefore you need to, you really need to come up with some decent argument on the merits, it is acceptable for the Court of Appeal to cut to the chase and say, well, right, which one of these grounds, which two of these grounds are the good ones? Right, boom, let's have a look at these. So there's no need to dilly-dally spending time explaining in detail why all the other grounds, which you've already been told during the hearing weren't any good, aren't any good. Finally, my lords, and I will stop. There are three further points raised in the appellant's case. They're actually best summarised in my case, because I extract them. Paragraph 60 of my case, the respondent's case, at page 1270. Paragraph 60. My lords, in the context of ground 1, the case as it was put below was a challenge to Officer Cash's evidence because he should have given the caution in Creole, or the statement should have been excluded because he didn't. The appellant now contends before the board that because the appellant said in his evidence, his live evidence, that he'd been beaten by the police, that he should have had a must-act direction. A must-act direction is basically saying, all about the admissibility of the confession statement and only admit it if you're sure it wasn't obtained in circumstances of oppression.
That wasn't put to prosecution witnesses.
No. But it's also a completely new point. And then there's the point about 229, which, again, I think we have looked at, paragraph 63 of my case.
On 229, you say it wasn't raised, and it was said that page 605 inferentially raises it, I think.
Well, for the submission, I think that's what's said against me, but maybe I'm being page 605. I haven't yet understood, I have to be honest, the relationship between the intention, section 12.3 of the Penal Code, and this point about section 299. 299 surely is a separate point about excessive force. Nothing to do with intention, as far as I can tell. And therefore, I don't see how it can be inferentially raised. And of course, it's not just that it wasn't raised below, and it's not just me being pedantic. The point is, if you raise that at first instance, there are strategic decisions to be made about what case you put to the jury and how complicated you make it and how many twists and turns you make and so on. And those would have to be canvassed at the trial. You can't say, twice removed before the board, oh, there's this great point under some provision of the Penal Code that nobody noticed, it definitely should have been applied. Because there are all sorts of reasons, actually, strategic reasons, why it may not have been wise to say, particularly when your client is saying, I didn't stab him. Oh, but if I did stab him, I did it in self-defence.
Well,
by the way,
self-defence clearly was left to the jury.
Yes.
I mean, I haven't myself looked at the closing speech to see whether it was raised, but I think it probably was, the impression I have. So that was clearly
yes. So then it's a question of, do you go one further and say, if the self-defence and provocation are rejected, can you then rely on 299 to say, well, the force that was used was so excessive because you were in terror or fear? I mean, it's very difficult. There's only so many different permutations of one set of already slightly vague facts that you want to put to a jury. And the point is, you can't not do that and then, for the first time before the board, say, well, here's this great point that wasn't put. Well, you can, but the response to the board should be no. If that makes sense. Shouldn't be allowed to run it.
So this point, the 299 point, you say was not raised below. So it wasn't raised in the Court of Appeal?
No.
Right.
Nor before the trial judge.
Yes.
Which, of course, it could have been. But as I say, I'm not really sure, given that the jury rejected the self-defence and provocation, where that would take you anyway. The only potential role it would play is if, well, I just don't understand where it would. I mean, if you...
Well, I suppose it could only, if the jury rejected self-defence on the grounds that excessive force was used,
yes.
then it would play a part.
Yes, because you don't, I suppose we don't know whether the jury rejected those
We'd
defences.
have to look at the summing up to see how it was put, really.
I think it's fair to say we don't know whether the jury rejected it on the factual precondition or the excessive force point.
But both 2991 and 2992 require a loss of self-control.
Yes. Yes. So if it can be reasonably inferred that the jury rejected the provocation defence because they didn't accept the facts that would trigger the provocation, then 2-2 goes with it. But I think my Lord Richard's point is we don't know why the jury rejected the provocation, because they could have rejected it.
Well, the provocation is a kind of taunting thing, whereas the self-defence is, he started hitting me, so I hit him back. Right, so they are... But provocation, even if it was made out, is this right, that it would only lead to a reduction of the offence to manslaughter? It's not a complete defence, whereas self-defence is a complete defence unless you use excessive force. But what you say is, well, this is all very complicated, and there are decisions to be taken as to how many layers you put before the jury when somebody's stabbed somebody in the neck with a knife. That's your...
And when their primary case is, I didn't do that. My lords, my ladies, unless there are any...
Thank you, Mr. Pennington.
Thank you.
Grateful. Subdaisy.
One point I want to come back to essentially. It's this point. The board, in setting out the test it does, paragraph 17 of Hamilton, the board, of course, and I'm mindful of the point raised by my Lord Richards, seeks to establish tests that can be applied generally to the circumstances that come before it on applications for extension of time to appeal against conviction and sentence. But what we say about Williams is that it's an authority of the Court of Appeal of the Bahamas, applying factors which we could say can be slightly more fixed or rigid, because murder appeals, that's what Williams concerned, which is the point correctly taken by my Lord Richards. Murder appeals with good prospects should be allowed to be argued. And we say good still allows flexibility on the facts of the case. So while the board might take a more general approach to discretion and a general approach to the test, the Court of Appeal of the Bahamas, as we say, channeled this general discretion to extend time in good cases of murder appeals, because it's the appellate court in the jurisdiction which has oversight over first instance courts. That's all I say on that point.
Anything further for Ms. Antesi? Thank you very much. Well, we're very grateful to Council for the very helpful submissions in this matter. And I include in that, of course, not those of witnesses today, but all Council in the case and all those sitting behind as well. We're grateful for the bundles which have been prepared. The Board will take time to consider what advice we will tender to His Majesty.